Hello, everyone, and welcome to our Planning with Purpose class or course. I'm Michelle. I'm the host for the course and today's class. This is literally like my fourth time recording this video because I forgot to hit record during the live session. And then I've come back to record it a couple times since, but then I kept forgetting all of this really good information. So hopefully this is it. Hopefully I've written it all down this time. So I'm going to refer to my notes. But the goal of this course is to be able to create a structured, easy to edit, easy to share, a secured, organized system of your financial life. And I know that that can be like really overwhelming because there's just so many different parts to it. And so what I wanted to do was like dissect the various important areas and then have us kind of tackle one topic each month and then break that topic down and just like really look at it and then work on different tasks throughout that month to accomplish whatever we need to kind of put that task or that topic to bed and to not only get done with it, but to make sure that it is in line with all of our other ones, because I think that's one of the biggest things that we see with hiccups in that is that maybe some of the parts and pieces that we do contradict some of the other parts and pieces that we've already done. And so I want to make sure that everything that you have is actually current, up to date, aligns with everything else, and it's easy to again, share and edit and review. So I think this is actually, I'm really excited about this because I think this is a really easy, an easy way of doing it. And I've structured the classes in such a way that the classes that we're doing at the beginning, we're then building onto those. So we're stacking the information and we're able to pull the information from those prior classes and use throughout the entire course. And because I don't know if you're anything like me, if I'm starting a project and I start to read the directions and it's like, I'm super psyched and I'm motivated to get it done. And then it's like, and by the way, you're going to need this first. And I don't have that. I totally lose motivation. I was digging like this raised flower bed and I got out there and I got in the dirt and I started going and I put together a little box. And then one of the first things after I got that put together and it was like, oh, and lay ground cover, not included. And so I'm already dirty. I should have probably read the directions thoroughly first, but I wasn't going to go to the store and get that. And that was a couple years ago, still didn't get done. So I don't want that to happen to you here. So in the first class, this is our fourth class. If you have not watched the other four or the other three classes, please go to our YouTube channel and you should have the link to the playlist. If you got this video, watch the other three. The first one we talked about creating your contact list, and that's just all of those really important people in your lives. And we wanted to make sure we had current information on them, and we were able to make, and we had a lot of suggestions on how to make it a shareable type of format and make sure that those people that you list on there know some of the other people. So if something happens to you, they can kind of reach out and tell each other and figure out what to do next. We also looked at creating a list of all of your accounts. And typically when we say accounts, most people think checking, savings accounts, investment accounts, 401ks, things like that. But there are so many other things. Like your debt. We need to have a list of all of the people that you owe, whether it's a mortgage, credit card, car loan, list all of those out. And we also need to see how we can access those. So we're going to need to have a list of all of the sites that you are signed up for. Like if you have a mortgage loan, list the site, list your username, list your password. You can do this really easy through a password manager, and a lot of internet browsers have that built in. So if you don't have, if you already have that built in, there's a way you can export it and share it, or just give someone your password for that internet browser. Or there's different services out there you can use like LastPass. but that's really important. Also, make sure that they know the different merchants you use. For instance, Amazon, Target, all these online shopping places, as well as your utilities. You may have electric, phone. You may have subscription services. And that's a big one because a lot of subscription services are done on maybe not a monthly basis, they may be on an annual basis. And if your loved ones are going back and looking at the last maybe few months worth of credit card or checking account statements, they may not see that on there. And that's something that if you have that listed, maybe the frequency when it comes out, they're going to be able to better assist in canceling those types of things. And another area that often gets overlooked is digital assets when we talk about accounts. And I'm not just talking about cryptocurrency. I know that's kind of a hot topic right now, but also things like PayPal. I had my husband actually had some stuff he had sold on PayPal, and it sat in his account for a while. And he was like, I thought I got paid for that, and just kind of forgot about it. And we logged into his PayPal one time. He's like, oh my gosh, there was almost $1,000 in there. And he had totally spaced on that. So make sure if you have something going into a PayPal or some other type of payment service that someone knows what that is. And a lot of people will sell stuff online. It's so easy now, whether it's like Poshmark or Etsy or eBay. Those things are really popular. And so you may have, even if it's a payment processing like PayPal, they may have something in there. Also, any type of rewards like miles or hotel rewards programs, they may have quite a few. I know, like with Gary and I, we travel a lot, and we have quite a few airline miles. We have, I think we're registered for just about every hotel program they have out there, and we rack up points. And so those all can be transferred to our heirs. And so just remember to list all of those. And then last month, we covered creating a home inventory. And we shared a really neat app, super easy to use. But we covered that because not only does it create the home inventory for your heirs, and it shows all of your property, it also creates it for your insurance in case you ever suffer a loss, whether theft or natural disaster. But it also lets you ensure that what you have is actually insured adequately. And so you may have some furniture that's an heirloom. You may have inherited jewelry over the years. And a lot of jewelry, if you've inherited jewelry, there's only a limited amount that your homeowner's insurance is going to cover. And that's usually about, I think the max is like about $1,200. So you want to make sure that if you have anything more than that in the house, that's covered in case of theft. Now, like I said, the way that we've structured it is you pull information from the prior classes. So we had the contact list, then we had the accounts, so we could see if we had beneficiaries on any of our accounts. If we needed to update them, we could use the contact list. And then for the home inventory, we could use the contact list to see if there was anything in our home that we wanted to leave to a specific heir. And then we could look at our accounts and say, well, if we're leaving something to an heir, do we need to leave some other, maybe cash, to a specific heir to kind of level that out as well. And today we're going to be looking at putting all of that in writing in our estate plan. Now, I'm not an attorney. I'm not a lawyer at all. And so we're not going to be giving any legal advice, just the basics on this, very generalization. And but I do think that we can cover some of the important documents that everyone should have. And I think I'm safe by doing that and just not providing, this is the stuff that you should have, and this is how you need to word it. First and foremost, last will and testament. And I think that's everyone knows what that is. And it just is a legal document that helps in giving your wishes or relaying your wishes and how you would like your assets distributed upon your death. And whether you have a trust set up I know people will ask, well, I have a trust set up and all my properties in the trust. Still important to have a will because you may still have something that comes to you, whether it's a rebate for something that you've subscribed for. Maybe you got the newspaper and you have a monthly subscription to the newspaper and you get a rebate that may not go through the trust. And so you want to make sure that you have a will in place just to cover that. Obviously, anything that goes through the will is going to need to be probated. So what is going to go through the will? What is not going to go through the will? Well, that's kind of where we looked at the accounts. When we looked over your accounts, your checking, saving, and investment accounts, we looked to see if there were any beneficiaries listed. And if there are beneficiaries listed or any type of contract law, anything that transfers with a rights of survivorship. So if your account is listed as a joint with right of survivorship or a transfer on death, which we call TOD, or a payable on death, which is a POD, anything that has something like that, it's not going to go through the will. And it transfers outside of the will. It transfers prior to, just requires a death certificate, doesn't matter what the will says. In fact, if I have a checking account and I have, let's say I have my spouse listed on it and it's a joint with right of survivorship, even if I list in my will that I want someone else to get that checking account, say it's American Bank 12345 even if I list the approximate account value, the account number, the date of that balance, and I put someone else as the heir to that, it won't matter. That is distributed outside of the will. It never makes it into that pot that the will is responsible for. And so it's important that we realize that, because that's some of the hiccups that we see that contradict what people actually may want to have happen. And we're going to look at an example of that in just a moment, where people adding someone to an account, not realizing the outcome upon their death, can mess up some of their estate plans. I mentioned POD and TOD. Those are basically the same things as a beneficiary. Now, with a joint with right of survivorship, that gives the person that is listed joint ownership with rights of survivorship. So they actually are a joint owner on that account at the time of while you're alive and after you're deceased. And so while you're alive, they can go in just like you can and take money out of the account. They can write checks on it. They can use a debit card. They have joint rights just like you do. And upon your death, then those funds or those assets gets moved to their name. Now, with the POD or TOD, what happens is they have no access to those funds until you die. So they can't go in and write a check. They can't get a debit card. They can't make a withdrawal until you die. Now, the only difference between the TOD and the POD is typically with the POD, it's going to be like a savings checking account, maybe like at a bank or say a credit union. And the transfer on death, or the TOD, is going to be more related to funds, stocks, those types of things. Think of it, it's easier to think of it like when you write a check at a bank off your bank account, it says pay to the order of. That's a POD, it's in cash. But when you're dealing with investments on a brokerage account, you have stocks, mutual funds, bonds, and that is a fund. And so you're going to transfer the fund to someone else because it's not cash. You're going to give them this piece of property. And so that's a transfer of ownership. With a same as the beneficiary, you can list it in certain proportions with the, I want 10% to go to this person, 90% to this person. You can do that with the beneficiary. And that's typically done on like life insurance policies, 401ks, IRAs, Roths, and that type of thing. Anything that is listed like that is not going to go through the will. So Should you list things like that on your account? Maybe. Do you want to give access to someone now or later? Possibly. We are going to look at that a little more when we look at some of the common mistakes, and I'll give you an example to show you how that can mess it up and what's the best way to kind of map that out and see if that's something you want to consider. Now, when we look at powers of attorney, there are a few types to consider. Most basic form of it is like a limited power of attorney or a special power of attorney. Oftentimes, if you're going to give someone a power of attorney that is very basic for one specific thing, for instance, if we have investment accounts for our clients, which we have quite a few investment accounts for clients, they often give us the power, the limited power to make trades in their accounts. We can buy and sell in their accounts. We can take management fees from their accounts. We cannot take money, a distribution from their account. So we have a limited power of what we can do. Where a special power, we may have a special power. We can do title work for a vehicle for someone. Not specifically, but that would be something that, as an example, someone could have. There's also a general power. And when we look at general, it's basically like you've got, like general is everything, right? In general, you get to do this. It's like it includes everything, and it does. I'm saying everything. If I'm giving you general, I'm giving you power to do everything, just like it were me. However, a general, while I'm fine, is great, but it ceases to exist not only at my death, but at incapacitation. And that's typically when people are going to need it most. I mean, I can handle things when I'm fine and I'm healthy and I'm here and I'm present, but I'm not going to be able to really handle things if I'm incapacitated. If I'm in a coma in the hospital, that's when I need something to be handled. And so the general isn't going to allow my power or my agent to be able to do anything for me in that instance. So what I could do then is I can give them a statutory durable, and it's durable throughout my incapacitation. And so that kind of covers both. It covers it before incapacitation and throughout incapacitation, still null and void at death, but it does open that window up a bit more. Now, if I don't want them to have it until incapacitation, what I could do is I could put a springing power, springing feature on it and say it springs into effect at my incapacitation, and then it's durable until my death. So it'd be a statutory durable springing power of attorney, or however they want to, maybe a springing statutory durable. I don't know how the attorneys are going to word that, but you get the point. Let's see, medical powers of attorney. Those are pretty basic. They give medical stuff. I can give someone a medical power of attorney, and they are going to have the power to make medical decisions on my behalf. I think that often gets confused with the living will, because that kind of covers some medical stuff. But that's more of, it also is referenced as the advanced directive. And that's looking more at life support, CPR, ventilation, feeding tubes, any type of like maybe organ donation, dialysis, those types of things, like end of life type of treatment. What do I want? Do I want to have life support measures? And if I do, to what extent? How far are we going? If it's determined that I am brain dead by a physician, when do we stop? And so I can put those things in place, because my medical POA may not be able to know, like, maybe there's hope. This actually happened with my aunt, that I was on a trip to Germany, and I came back, and my mom had told me that my aunt was in the hospital. She had surgery. And when I got back, she said she's not doing very well. And when I got to the hospital, my uncle was totally in denial and said, "Oh yeah, she's great. Look at her oxygen level and her blood pressure and her pulse. And when I talked with the doctor, she was on life support. And so he couldn't, he couldn't pull the plug. He saw all of the machines and all the levels looked great, but he couldn't fathom the notion that if we stopped those machines, it was not going to stay that way. And so I was her backup medical power, and she did not have a living will. And so we had to really discuss that and her wishes of what she wanted and what she had talked to us about. But if she had left that in writing, it would have made it much easier. Another important piece of estate planning is a Hipaa authorization. And this is basically a medical information release. I can provide that to whoever I want. And it's not to make decisions in any way, but it's just to release medical information to them. So if I want my brother and my sister-in-law and my parents and my sister and my son and my husband all to have, if I get into a car wreck, I want all of them to have the ability to call the hospital and find out how I'm doing. I need to list them all on there. Because if I'm admitted to the hospital, obviously the medical staff can ask me upon admission, is there anyone that you want to have, your information released? Yeah, I can tell them, they can write that down, and that's great. But if I'm in a car wreck and I'm brought in and I'm unconscious, I can't provide that information to them. And so by having this and providing it, and that's the big point, providing this paper to them so they can then present it, that's what's going to get them my updated medical condition. And so make sure that you do provide it. And this is not just like if I take it to the hospital and give it to them, it's not just a one and done or hit it and quit it type of thing. It's in every admission. When I would go with my dad to Dallas when he was doing his cancer treatment, every time, and sometimes it was like 2 or 3 times a month, every time we would go to the hospital, I would need to present the medical POA as well as the Hipaa authorization every single time. And so it was like, you're just here like last week, but they wanted it every single time. It's per admission. So make sure that you provide that to those individuals that you want to have access to your medical information. There's another thing. Has zero legal standing. It's more informative. It's called a letter of instruction or letter of intent. And it's kind of an informative thing that you can share with those that you leave behind, your loved ones, and just say, I understand that this doesn't go into a will, it doesn't go into a medical power or general power of attorney or durable power of attorney, but these are some of my wishes. And like I said, it doesn't have any legal standing, but it does provide certain guidance for those that, may be struggling with making decisions on your behalf. One of the things that my dad had mentioned, and he just passed a couple weeks ago, he wanted to not have like doom and gloom. He wanted to have a small service, and then afterwards he's like, I want everyone to get together and just share memories and listen to oldies music and and eat barbecue. And that was what he wanted to do, and we had it in writing, and it made it so easy. We catered barbecue, we blasted some oldies, and had like a slide on all the different TVs, and he was there. And so it just made it so easy that he told us exactly what he wanted, and we didn't have to come up with those decisions, because I'm telling you, when you are in that fog as someone that lost a loved one, you can't make decisions. So by taking that responsibility and that burden off of your loved ones, amazing gift that you can give to them. Let's see. Prepaid funerals are definitely something to consider. And I added this in. So this was not something that I think we touched briefly on it in our live recording or our live class, but prepaid funerals, if you haven't looked into it, definitely might be something to consider. I did mine 10 years ago when I lost my when my late husband passed, and it was super cheap because I was so young that I was able to get that done. And at the same time, my dad ended up doing his. And so when we went in upon his passing, it was a breeze. He had everything listed out. We had everything prearranged. All we did was go in there and provide the obituary, figure out how many death certificates we wanted, and we walked out. It was so nice to not, again, have to make those decisions. Another thing that, a lot of the people that were at the service did not know this was possible. But if you've served in the military, definitely check in on this. It's the National Cemetery. I think this one is the Fort Sill National Cemetery is our closest one. It's not on Fort Sill military base. It's in Elgin, Oklahoma. But there are national cemeteries all over. But they have where they'll bury or intern those that served, and there was no cost to it. This is part of an offering for serving our country. And it qualifies like we did my grandmother and my grandpa. He was military. And so they were both cremated, and they were both interned together in I'm not sure what you call that box, but in the wall together. And so the spouse was able to be with the husband. And we did the same with my aunt and my uncle together. And so it just made it so nice that they are right there together, and they engrave or inscribe the faceplate, and they had like the little military honors there. And it's a beautiful place, but it was totally free of charge. And they really keep on these national cemeteries, they really keep those up gorgeous. And so definitely look into that. It just requires a DD 214. So if you have a copy of that, pull it up, look for one in your area, definitely something to consider. Now, some of the common issues that we run into that are, I think, I would say inadvertently made. I don't think people are intentionally trying to, mess things up. But I think some of the mistakes that result in the changes that are made, one of the biggest ones revolves around account titlings that contradict the wills. And an example of this would be, let's say you have a widow, and of course they want to add someone to the account to ensure that if something happens to them, if they're hospitalized or become incompetent, that they want to make sure that someone can step in and take care of things on their behalf. And so what typically happens is they'll grab one of their kids, the one that's closest to them, usually geographically closer, not just like they, love them more, but that's geographically closer. And they'll ask, they'll add them to the account so they have signing ability on that. And so let's use an example of a widow, and she has a daughter in town, son out of town. Her goal is to leave her estate 50-50, split it between the two kids. And let's say that everything is set up that way, and she ends up going into her bank to add daughter to the account so she can sign checks, she can pay bills, she has online access to make sure she looks at her statement. She wants to make sure that there's no elder financial exploitation going on. She can actually look and make sure everything's cool. And then mom dies. even if mom has that checking account, like I mentioned before, listed in the will, that account, if it was listed, if she added her as a joint owner with right of survivorship, which is pretty common when you go into a bank and say, I want to add this person as a joint owner, that is what's going to happen. That is not going to be part of the estate. So son is not going to get any of that money. Now, daughter may be nice, split it with son, but then you're running into some issues where there's a gift tax return, because there's only I think it's now 16,000 for an annual exclusion on a gift, or you have to file a gift tax return. And so there's some issues that need to be handled, or some further paperwork that needs to be handled with that. And so she has the ability to do that, or she could say, okay, no, I'm not going to take this, and then what it goes to the estate then, I guess. But it would be kind of silly that she just wouldn't take any money when that was the whole point, trying to not keep it in there. Now, there are ways that mom could have done this by giving daughter access to the account to sign on checks and to check the account, have online access, but still split the account between the two kids. She could have given daughter power of attorney and then put a POD on the accounts. That would have worked just fine. And even if she didn't put a POD on the accounts, just having power of attorney would not give daughter rights to the account upon death. It would go to her estate, and then it would fall under the will. And whatever the will then said, whether it listed that account or not, whatever her will said, if it says everything goes 50-50, fine. Then that's how it's going to pan out. So there are ways that can be handled. And so I think it's important to realize what happens when you change the accounts. And that's why when people ask, can I do these things like online with like LegalZoom or just type something up on my own? You can, yeah. But do you know, and do you understand how to review all of these things to make sure there's not contradictions between them? And that's what I fear, is that maybe not understanding how things are going to trickle down and actually accomplish what you're wanting to accomplish. I just want to make sure there's no contradictions in that stuff. So an attorney will do that, and LegalZoom doesn't. So yes, you absolutely can use LegalZoom, but I think it's important to look over these things. Now, that's not to say that you go to, you can go to an attorney, you can get everything set up, and then you have everything in place, and then you can go change the account at that point, and it's still going to mess it up. So it's changing things is what is going to be the problem. So definitely look into that and see what those changes are going to do and what they're going to do to your estate. Another issue that gets brought up is co-signing a loan for a child or a grandchild or a friend or someone else. Where do those funds, or where are those funds supposed to come from if that person cannot refinance that loan in their own name? And the reason they may not be able to refinance that loan in their own name, maybe they don't have credit that's established enough or high enough credit score to get a decent loan. Maybe they don't qualify for a loan at all. And so maybe they just got the loan and there hasn't been enough payment history to bump their score up high enough. So where are those funds going to come from? Don't know. Should arrangements be made? Should you add a life insurance rider onto that loan? Should a separate term policy be taken out? Should something be designated for that? And I can't tell you. that's where you would have to kind of map things out. And actually the best thing to do for all of this is to like kill yourself now. I mean, not like literally kill yourself, but on paper, say, if I died right now, how is my checking account going to pass? How is my savings account going to pass? How is someone going to access my cryptocurrency? How is my IRA going to pass? Who is going to be able to access my credit cards and my rewards programs and everything else? How is my car going to be retitled to the person I'm giving it to? Figure it all out and then see where those hiccups are. And that's the area to work on. Another area that we see is leaving specific property that appreciates differently. So let's say that you have a house / ranch / a big parcel of land versus a pretty sizable IRA. Well, let's say that pretty young when it happens, and that maybe over time, mom has to start drawing down on that IRA, and that land continues to go up in value. Well, and this is becoming disproportionate. And so how are we going to kind of offset that to get it back if we're wanting to give kids the same amount of money? And again, is that something that maybe a life insurance policy or some type of other property being included in that best? Maybe instead of doing the IRA, maybe earlier on, we can start shifting some of the IRA funds, doing some Roth conversions to offset some of those taxations, because obviously in an IRA, even if mom's drawing it down, RMD is required. If daughter inherits it, let's just say daughter's inheriting the IRA. If daughter inherits that, mom dies, daughter inherits it, she'll have like a 10-year payout, and she's going to be paying taxes on that. And yes, I know that the house, land, big parcel of land and ranch or whatever is also going to have taxes and upkeep and all that stuff, but it doesn't have to be paid like in full in 10 years, where a beneficiary IRA is going to have to be fully pulled out within 10 years. So it can force that person or that heir into a higher tax bracket, depending on what their tax bracket is and how large that IRA is. And so by shifting some of that and doing Roth conversions, anything in a Roth is not going to be taxable. So it may, if we're looking at how that's going to pan out tax-wise, that may be an option as well. Now, going through a lot of this and going through a bunch of my dad's stuff, I was doing a lot of probate research, and something I came across is that interested me was a due on sale clause, which I know that there's due on sale clauses on contracts. And if you don't know what a due on sale clause is, it means that, let's say that let's just say that my dad has a car loan, and that I'm now going to change the ownership and take over that car, and I'm going to put it in my name. Well, to do that, I have to pay the bank off because I'm changing the name on it. So I would pay the bank off. And whether I'm going to pay cash or if I'm going to refinance it, either way, it's going to pay that off. They're going to say it's due upon sell, because that's a sell to me. Now, even though it's an inheritance and stuff, they would say, okay, yeah, you need to pay that off. And basically it's just if you're selling or transferring property to a new owner. Now, that can cause some issues in that, let's say that you have an older couple, and maybe let's use my grandparents, for example. My grandma didn't like work maybe a couple years in her whole life. And so she took care of the kids, and there were 5 girls. And so she took care of the kids, and through school. She taught him how to sew. She made dinner. She made cookies. She didn't work. My grandpa worked his whole life. And so when my grandpa died, if they had a mortgage, my grandmother, if this due on sale clause was in place, and my grandmother, let's say that she wasn't on that loan, let's face it, years and years ago, it wasn't like joint owners. They didn't have to be on that loan. Most of the guys had the loans. Women weren't working, so they weren't on there. So let's say that she wasn't, and now she had to be because she had to qualify for the loan. She didn't have a credit score. She didn't have a job. She may have gotten a bunch of insurance money, but maybe she didn't want to pay it all at once. Maybe she wanted to continue to make payments so that money could grow. Maybe she were going to buy a bunch of CDs when CD rates were like 15%. What if she didn't want to do that? Well, there's nothing she could do. She may not qualify for a mortgage loan. And if the mortgage company or the lender had that due on sale clause in the contract, they would have said, pay up or we're taking the house. This is really interesting. So back in like 1982, and I'm looking at my notes, it was the Garn St. Germain Depository Institutions Act of 1982. Property, banks can enforce the due on sale clause, except if it's a second mortgage. Now think about that. If it's a second mortgage, then the lender is going to add their mortgage or their lien to it. So obviously you wouldn't want to have to refinance it at a higher rate, especially like now. Like 2 years ago it was like 2% rates, and now it's like 6.5%. So a second mortgage, termination of a joint owner. If you get divorced, you have to refinance it at maybe a higher rate, especially if you don't qualify. You had two incomes and now you're going to have one, and maybe the rates were higher, and maybe you don't have as much income, so you get a higher rate. Transfer of ownership to spouse or child of borrower, or to a relative from death of borrower. So really interesting on that. If you are in a situation like that, talk with an attorney, because they can the lender can add you as a successor in interest. And that means that you can keep that loan in the deceased person's name, basically the same terms that they had, and continue to make the payments in certain situations. And so it was really interesting to find that I had not heard of that before. I don't know why I'd never heard of that before, but interesting. So if you find yourself in that type of situation, talk with an attorney about it. Again, if you feel comfortable using online services to do like LegalZoom or something like that, sure, absolutely. Just make sure, again, that you map this stuff out, see what is going to happen. And like I said, on paper or do a spreadsheet or whatever, and like virtually kill yourself. We do this all the time when we do like real financial planning. We will virtually kill both people off at different times. And we check all kinds of things like Social Security optimization analysis. We'll look to see if there's life insurance needs. And we'll also check this kind of stuff, because what happens if this happens? And also, we didn't really talk much about trust, because there are so many. There's living, testamentary, revocable, irrevocable. There are different subsets of trust. Like you can have a marital, a bypass, charitable, generation skipping, life insurance. There's all different types of things. There are reasons that you may want to have a trust. And if you're looking at doing like a LegalZoom type thing, please don't, unless you're really, really, really skilled in this type of thing, because it can get very squirrely. There are types or situations that you would definitely look at getting a trust. One that's pretty popular around here, we're so close to the border of Oklahoma, you may have property in 2 different states. And if you do, you would have to, if you died, you would have to do probate in 2 states. So you have probate in the state you're living in or you're domiciled in, and then you would have ancillary probate in the other state that you're not domiciled or you're not living in. You would have ancillary probate. So twice you have to go through it. And so if you had that in a trust, that property in a trust doesn't die. So you wouldn't have that probate to go through. So that's one. Also, another reason that people may want to do probate is that it put stuff into a trust is that it avoids probate. I wouldn't necessarily create a trust just to avoid probate. I know Texas is like super, super duper easy to die in. And so it's pretty cheap as well. You may want to establish a trust to kind of keep your dirty laundry from out of public record. But if you do probate, it's public record. And so it's all out there, all for, all your properties out there for everyone to see. And that's why a lot of people may choose to set up a trust so they it's not public record. Also, people may set up a trust to kind of shelter assets from creditors. And so if you're in a position or employment or profession that is maybe a high litigation type of position, then that would also be an option. Another option is if you are in a blended family. And I say this because this is a pretty common one, about 65% of people in the US are in a blended family. And what does that mean? Well, let's say that I have, I'll kind of give you partials here because not all of this is true, but I am a widow and I'm remarried. So let's say that my house is something that my late husband and I purchased, and I have a son. And my son's out of the house. He's grown up. He has his own house. But my new husband, let's say that he has a child. Like if something happened to me, I wouldn't want my husband to be, pack your bags, get out. But if I would want him to continue to live here, but I wouldn't want him to sell it and then just go buy something else and leave my son out. So what I could do is set up what we call a life estate. And then it would say that he can continue to live here, but if he goes to sell it, then the proceeds would go to my son. And that's important because who's to say that he wouldn't remarry? And then some bimbo comes in and she has a kid. And now if he dies, my kid, and let's say his imaginary kid gets nothing, and her kid get everything, and they've worked nothing for. And so that's not how we would want it to be. And that's not how he would have wanted it to be. That's not how I would have wanted it to be. And it's certainly not how my late husband would have wanted it to be. He didn't even know that chick. And so that's not something that we would want. In addition, if I have my IRA and I die and he inherits my IRA and he does it as a spousal, meaning he rolls it into his and makes it one, then if he remarries, then if the spouse doesn't consent to, putting another beneficiary on it besides her, then she's the full beneficiary. That could be mostly mine. And I don't want that. Maybe I want my son to have it. And so if my husband dies, I want my son to have it, not the bimbo. And so instead of doing it that way, we may say, instead of putting it into a spouse, so we either do it as a beneficiary, IRA, and there's going to be some other things that happen there that we're going to have to start RMDs faster, or we maybe set it up as a trust as a beneficiary. And so those are some things that you would want to do and look into a trust for, because it's when you're looking at blended families, there's so many different parts. You want to protect your heirs. You want to also protect your spouse, but you have to look at what can happen after you're gone. and what then could happen after maybe they're gone. And so you have to cover all areas of that. So trusts do have places, whether you need one, whether you don't, whether things can be handled outside of a trust just through contract law, that is possible as well, but definitely something to consider. So if you have not watched the other videos, please go back and do that and get caught up. It was the contact list, accounts, home inventory. Don't expect anyone to be done with the home inventory. That can take through the rest of the year. I don't suggest rushing that. I had suggested doing maybe one room per month, or I'm sorry, one room per week. Then start working on this stuff. If you do not have estate plans or estate documents in place, get some estate documents in place. If you feel comfortable, if you have a pretty basic thing, a pretty basic setup, then, and you feel comfortable doing online stuff, we have a system that is for advisors. It's called Trust and Wills, and it's super cheap. I think for a couple, for your last will and testament, statutory durable, medical, and Hipaa authorization for both spouse, both parties of the marriage. I think it's like $250, a little under $250. For an individual, I think it's like a little under $150. And so if you're interested in that, we can get you a prepaid code, and then you just we'll send you an invoice. And if you're interested in setting up anything, like having it to where you can share different things like your Hipaa authorization, medical power of attorney, and power statutory durable, we also have a system called Everplans, and it's like an online digital vault. If you're interested in that, shoot me an email and we will get that to you as well. It's Michelle@personalmoneyplanning.com. We'll put it in the comments below. But get working on this stuff, and if you have any questions, shoot me an email. I guess other than that, until next time, take care.